All rise. Court of Appeals Division 1 is now in session.
Good afternoon. You may be seated. I don't know if we're still morning. We're here in the case of, forgive me if I mispronounce this, but Thienes versus City Center. Our case number is 1CACV140077. Each side will have 20 minutes for their argument. These proceedings are being both audio and video recorded. We'd ask you to identify yourself and your client when you start your presentation. We have conferenced this matter. We've reviewed the briefs, and we look forward to your argument. And with that, appellant, you may proceed.
May it please the court, my name is Dan Barr, and I'm here together with Josh Crum and John Gray, representing the appellants, City Center, Executive Plaza, Jerry and Cindy Aldridge, and Information Solutions. At this time, I'd like to reserve 2 minutes for rebuttal in my time. This case arises from a highly publicized and bitterly contested political and legal dispute in Mojave County during the past 4 years. It has involved a referendum in Lake Havasu City, an attempted referendum in Mojave County. It has involved 2 Superior Court judges and multiple trips to this court. In this case, the trial judge repeatedly abdicated his duty to decide issues of law and simply passed those issues off to a jury. And in doing so, he passed along to the jury doctrines that are meant to promote and protect the transfer of real property in this state, as well as ignored various legal documents that govern this case. The trial court's refusal to address and decide issues of law is reflected many places in the record, whether it be 1, ignoring the legal burdens to pierce the corporate veil, 2, allowing claims for third-party breach of contract when the plaintiffs fail to identify the existence of any contract that named them as intended beneficiaries in the contract itself. 3, accepting as parole evidence the testimony of people who were not part of the formation of the documents they were testifying about and attempting to interpret. And 4, awarding attorney's fees for coffee, meals, and travel. The trial court's abdication of its duty to decide issues of law is no more apparent than this astonishing statement in its findings of fact and conclusions of law, stating, quote, "The jury's binding verdict in City Center's favor on the breach of contract claim necessarily means the integrated lot purchase contract, which incorporated by reference the CC&Rs, contained no restricted covenant." The trial court goes on, "As a matter of law, an implied covenant cannot trump an integrated written contract for the sale of an interest in real property. However," the trial court said, "that is not how the jury interpreted this testimony and the facts." Well, if something is a matter of law, the jury doesn't get to interpret the testimony and the facts, and it is an issue for the judge to decide. And more importantly, as set out in the amicus briefs filed in this case, if the trial courts are simply going to pass these issues along to juries and engage in, after 4 years of litigation, people simply aren't going to invest millions of dollars in projects in real estate in Mojave County if everything becomes up for grabs, no matter what the legal documents say.
Mr. Barr, can I ask you a question? Going back to one of the first points you raised here about piercing the corporate veil.
Yes.
And I was trying to understand in the scenario, or maybe I just missed this, when the property was transferred from City Center to the Aldridges personally,
Right.
and before they transferred it on, what was there some I didn't understand why that happened, and I didn't see what the consideration was, if any, going to City Center for its transfer of the property to the Aldridges.
Your Honor, what I understand was being separated out for accounting purposes. The Aldridges have 2 closely held corporations. Sitting here right now, I'd have to go back and look at the record to see what consideration, if any, occurred at that time. The Aldridges owned the golf course for less than a day before passing it along to Information Solutions. So, I mean, I could go look in the record to see what that consideration was.
So the best argument then would be that they were straw men for, akin to an escrow.
Well, yeah, I'll tell you what the purpose was, is that they were taking the golf course property out from the city center, moving to Information Solutions because their accountant told them for accounting purposes they had too many things under the city center bailiwick, including a building in Lake Havasu and the like, and advised them that you should separate the golf course out and put it into a separate entity it would just be a lot cleaner for accounting purposes.
Well, I'm going to show my ignorance now of corporate or possibly tax law, but why wasn't that simply a business-to-business transfer or between the two corporations?
It should have been, and I think they did this themselves in the first instance before getting legal advice. In doing so, I mean, the step of transferring it to them for a few hours is and then setting it on to Information Solutions is meaningless. I mean, it should have been done from city-centered Information Solutions, but the result is the same. There's nothing in the record that the Aldridges did anything with the property during that less of a day that they held it. And again, that is one of the missing links in their argument to pierce the corporate veil, that the Aldridges did something untoward or fraudulent during that time that they owned the property, and they simply haven't shown that.
Well, as I remember, the jury was pretty fully instructed on piercing the corporate veil. Is it your position that that's purely a question of law that the trial court should have ruled on?
Well, yes, Your Honor. In this instance, it was an issue of law. There were insufficient facts to send it to the jury. I mean, there was nothing in the record that the Aldridges had failed to comply with the corporate form. There was nothing in the record that they had committed some fraudulent act to say that you should ignore the corporate form. So with that, the matter summary judgment should have been granted, and the issue should not have gone to the jury. Your Honors, this is a case about a situation that's occurring all over the country. For the last 15 years or so, golf courses have been failing. And in 2009, the Golf Course and Country Club at the Refuge failed. It was losing $1 million a year, and Home Federal Bank, which was a lender, purchased the Golf Course and Country Club out of foreclosure at a trustee sale. Our briefs thoroughly discuss why Home Federal Bank and City Center are bona fide purchasers. There is no evidence in the record that either of them had any knowledge of a golf course only restriction, and that they acted in bad faith.
But could I just take it a step back, and unrelated to the point you're now making, but
Sure.
Assume just the original developer had just gone 6 months and decided this golf course is not economically feasible. Would it be okay for that original developer 6 months after selling all the lots to come in and decide, I'm going to build a football stadium or an RV park or something on these lots?
Yes, Your Honor, because the documents allowed that, and because the lot purchase contract told people what they were buying, what they could rely on. The lot purchase contract of the CC&Rs told them that the golf course could be changed. In fact, it said the golf course could be closed and removed. It did not guarantee them views of any type, and that these people did not have an economic interest in the golf course. So yes, they could have done that.
But there's nothing wrong then with making these avowals that we're developing a community around a beautiful golf course, and 2 months later we decide that's not economically feasible, and we're going to build giant buildings right outside your back door? Well,
as always, Your Honor, it depends on what the documents say. In the cases where these implied covenants are enforced, the contracts don't have express clauses informing people that they can't rely on the continued existence of the facility, that things can change. I mean, what happened here is not only did you have the documents informing them that the golf course could change, you had an integration clause in the contract saying whatever people told you as far as in sales presentations and marketing materials, you can't rely upon. It had a disclaimer clause in it. I mean, all these people who are buying these houses are sophisticated business people. They own multiple houses, and the documents here were expressly telling them what could happen. Now, the question is, what could be built there? Well, the zoning told them what could be built there. The CRE zoning listed several uses of what could go on that land, other than a golf course, and RV parks was one of them, along with hospitals and schools and the like. So anyone doing their due diligence here, the documents told them exactly what could happen.
What's the clearest citation in the record you can come up with that says the golf course can be removed in its entirety?
Your Honor, it's in the CC&Rs. Let me find it here. I'll find it when I get up on rebuttal. But in the CC&Rs, it says the golf course. There's no promises that the golf course will even be built, and the golf course they could cease operations of the golf course.
Ceasing operations is one thing, because as I see it, there's not a claim here for the affirmative right to play golf, as much as the negative right to be free from nuisance, and that's significant. I mean, was there anything in the CC&Rs that said the golf course property can be used unrestricted in any way that zoning permits?
Your Honor, I'll find it when I sit down.
Well, okay, but I'm not asking you for the quote. But
yes,
right
Your
now.
Honor.
So
yes, I mean the people were fully informed.
Well, apart from being fully informed that you can't trust salesmen, were they fully informed that this golf course idea was entirely illusory and could be transformed into anything at any time?
Well, this is what
I don't recall seeing.
This is what they were told in the CC&Rs. Section 2.5, the declarant can change or modify the development plan with respect to any property owned by the declarant in any way the declarant desires. CC&R Section 4.1, the lot owners have no property interest in the golf course. CC&R Section 4.3, each lot owner acknowledges that no representations or warranties were made by the declarant or any other person regarding the use, nature, or size or improvements or continuing ownership or operation of the golf club facilities.
Well, perhaps that's why the jury concluded there was no breach of contract. But the question I think Judge Swan may be asking is, these documents don't, the existence of this language in these documents don't end the inquiry as to whether a condition can be created that is the equivalent of a nuisance.
Sure. Well, let me talk about the nuisance claims. The private nuisance verdict here is infected by all the other claims that should not have been heard by the jury. After concluding other claims that the RV park was not permitted, the jury, of course, would then be easy for them to determine that the RV park was unreasonable. Moreover, the trial court's error in not holding that this court's decision in the Schilling case collaterally estopped plaintiffs from arguing that there was a express covenant that limited the zoning also infected the private nuisance verdict. As a matter of law, a land use that complies with applicable zoning and has received all the necessary approvals of the county board of supervisors and other county agencies should not be considered a nuisance per se. Indeed, the Supreme Court in the Armory Park case said that we agree that compliance with zoning provisions has some bearing in nuisance cases. Here, City Center was entitled to a presumption that the RV park and the event tent were not nuisances. Instead, the trial court rejected the jury instruction that we offered, and plaintiffs were able to argue to the jury that the Mojave County zoning had been narrowed by an express restrictive covenant, and that the RV park and the event tent were, quote, inherently a nuisance. Now, the jury was presented with public and private nuisance verdicts. They rejected the public nuisance verdict and found a more limited private nuisance. But the remedy doesn't reflect that. The Supreme Court in the Spur Industries case said that where the injury is slight, The remedy for minor inconveniences lies in an action for damages rather than one for an injunction. And Arizona law is quite clear on what the standards are for entering a permanent injunction. There are 4 questions. First, has the plaintiff suffered irreparable injury? Well, the answer here is no. The jury found that they had been damaged to a total of $1. 2, are the
Is that necessarily inconsistent with an injunction? I mean, I suspect that if the jury had found that there was damages of $150,000, you'd be saying, well, that means there was an adequate remedy at law.
Well, I think I was about to say there is an adequate remedy of law here.
Right, but you can't have it both ways. If the jury finds that an injunction is the only way to remedy this and will enter a nominal damages to show that there was liability, that doesn't defeat the injunction. Doesn't that support
But
the
it does inform one whether injunction is necessary. Is if over the course of 3 years there has been $1's worth of damage, and the dollar damage was on the third-party beneficiary contract. I mean, the jury awarded nothing for the nuisance. I mean, that should inform what the harm is here, and to have a injunction that shuts down a good part of the business when the plaintiffs have suffered no damage. And you put on the other side of the scale people who've invested $8.9 million in an enterprise.
But what I'm
I mean,
getting
that is inequitable.
Logically, it sounds like you're saying if the jury awards no damages or nominal damages, there can't be an injunction because you haven't suffered any harm. And if they offer substantial damages, there can't be an injunction because you've got an adequate remedy at law. So,
But that gets to this. I mean, there are 4 questions. Then the question is there an adequate remedy at law? The plaintiffs certainly thought so. They presented a damages expert where they sought $16.2 million in damages.
But they also very clearly sought an injunction.
They sought an injunction as well. That's correct, Your Honor. But I mean, you have to be informed by.
But couldn't the jury conclude that the biggest damage is the nuisance to the homeowners, that it damages their prospective views, and we're just not going to award that much for, so you've had a couple of years worth, but certainly looking out into the future, why isn't that an award of essentially of damages?
Well, Your Honor, when the jury has concluded that they have not been damaged at all, taking all their evidence for all it's worth, that they have not been damaged at all in the past 3 years by this supposed nuisance, it doesn't make any sense to issue an injunction shutting down the entire enterprise. I mean, if that's the other thing where looking at the balance of hardships here, as I discussed, you have people who haven't been injured at all versus people who have invested a tremendous amount of money in the enterprise. And the injunction is not even narrowly tailored to what they're complaining about. If there's an issue of traffic, you could have an injunction saying you can't park on the association roads. If there's an issue of noise, you would say you can't. I mean, this is a country club facility, after all, and people have to expect certain things, but you would say you can't have loud noise after 10 o'clock at night. If there's an issue about security, you would say you would add extra security. You don't issue an injunction tearing down the facility. If somebody's has a bunch of teenagers across the street and they're having loud parties in their house, I could get an injunction saying, hey, you can't have loud music after 10 o'clock. I wouldn't get an injunction ripping down their home.
Isn't part of the requested relief, though, have to do with the destruction of views, the expected views from the...
And, Your Honor, that's exactly what the CC&R say that they don't have an expectation to. I mean,
minimum that it won't be there's no particular view that's out there, but you can assume that it won't be a 20-story building built 10 feet from your property line.
If that were the case, this would be a different case. I mean, what this is a situation is they've shortened the golf course from 7,200 yards to 6,600 yards. They've repurposed 6 acres of the golf course for the motor coach resort, and the closest that any house is to it is 150 yards. So, Your Honor, I see I have a minute 30 left. I'd like to reserve the rest for rebuttal. Thank you.
Good morning, Your Honors. My name is Franklin Jeans, and I'm with Corey Broadbent and Lucio Berezowski on our team. We represent the thinnest group of plaintiffs. With us is Penny Kepke, who's with ECMAR, and Nicole Miller, who will some parts of this, because we're grouped
We'll need you
together.
to speak into the microphone for the recording. Thank you.
Usually with my voice, I don't have that problem, Your Honor, but I'll speak in with, what we're going to do is divide this up, if that's all right with the court. Ms. Kepke will take care of nuisance, and let me get my list here.
Good morning, Your Honor. I'm Penny Kepke with Ekmark and Ekmark. My client is the Refuge Community Association, the appellee in this proceeding, and at trial I also represented 4 individuals who served on the board of directors of the Refuge Community Association. I'll also be handling the issues related to the declaratory relief and the injunctions that flowed therefrom regarding the easement rights to the golf club owner and the declarant under the CCNRs.
I'm going to handle implied covenant, express covenant, and equitable servitude, and those third-party contract, those related issues, and the alter ego. This case is. Hold on a minute here. This case is one of importance. It's been bitterly, as Mr. Barr said, contested, primarily because you're talking about folks in their homes. Those are usually very contested matters because it's the most important single asset and personal asset that a human being gets. What has happened here is that a man and a lady have purchased, as you know, the golf course and some other related properties and tried to change them when that golf course was the center focus of the community. It was the ambience of the community. What is going on today, and as I went through and listened to Mr. Barr, what Mr. Barr would like to do in this appeal is to relitigate the facts that were litigated before the jury. Every legal principle that he brings up is predicated on a fact that was presented to the jury and which the jury failed to find in his behalf, so that we end up with a series of facts being told to you that in fact aren't facts. And I'll give some examples. The answer to the question of whether or not there was any consideration for the transfer from City Center of the golf course from City Center to the Aldridge's to Information Solution is no. There was no consideration. And in fact, City Center itself had assets, some other assets, including an office building. The Aldridge's personally had assets, but when we get to Information Solution, it was a dormant corporation, which was an empty shell and had no assets. Ultimately, it borrows money, but it doesn't itself have any assets except for the golf course. I'll let Ms. Kepke argue what that represents, but to us it represents one of the continuing efforts of the Aldridges to play fast and loose with a corporate or limited liability entity, which eventually the jury saw. I mean, what you don't get to see, unfortunately, in these cases is you don't see the demeanor of the witnesses, and the jury here spent 15 days with Mr. and Mrs. Aldridge and the other witnesses in this case, many of whom are here today. The board of directors of the association is largely represented here today. And what you saw was a circumstance in which Mr. Aldridge thought that he was, for a fellow who could do anything he wanted to do without regard to his corporate entities, and he did it. And he was proud of it, and he said he was proud of it. And so therefore what we had is this jury see exactly through that, and the judge agreed. After we've tried this case for 15 days, the jury was out for 2, came back with verdicts, which you've seen, and the judge then took 8 months. He didn't make a decision right away. He took 8 months to review the entire trial record. Part of the reason that it took so long was to get the trial record. And at the end of the day, while he personally indicated there was problems for him personally in thinking about this matter, he came to the conclusion that the jury had got it right. And we suggest to you the jury did get it right. And in suggesting that, what we think you should focus on here, and what we think this case is really about, is Shalimar. This is, as Yogi Berra liked to say, deja vu all over again. If you compare the facts in this case with as found by the jury with the facts in Shalimar, the fact of the matter is this case is another Shalimar. You had a developer who came in who built a golf course community, got a premium for lots all over the place, partly for views, partly for being adjoining the golf course, and in fact then lost the property to the bank took the property over, operated the golf course, operated the property as it had been done by the original developer, and eventually, within a few months, sold it to Mr. and Mrs. Aldridge, who came to the property with a predetermined position that they wanted to change it and turn it into an RV park. They wanted to put in originally 300 to 400 RV park pads on the golf course. And they were shocked, they say, that they, in fact, that the homeowners, particularly a guy named Thinnis, who's in the audience with us today, who happens to own the lot right over the first tee, he got upset. He said, no, you can't do that. And eventually the association agreed with him. And eventually that we ended up with this long trial, and we have our position.
All right, Mr. Jeans, excuse me for interrupting. I want to.
No, I would like you to interrupt, because what I was about to say is we're here to answer your questions.
I want to make sure I understand you. I'm familiar with the testimony you referred to by Mr. Aldrich, and however you want to characterize it, that he was either boasting or proud that he and his wife were making the decisions. What I'm trying to understand is what evidence was there that the Aldriches disregarded the corporate entity? In other words, what was there evidence admitted at trial concerning the documents surrounding the formation of these entities, that there were meeting minutes, that otherwise the structures were honored? Other than this transfer.
The one thing that the Aldridges did seem to do, as we understand it, although I'm not sure it's in the record, but we will admit that they kept minutes of their meetings and they did the things that you would normally do to keep a corporate existence, at least with regard to City Center. That we know from their deposition testimony. Whether that got into the record, I can't tell you exactly. What I can tell you is that's about the entire sum of it. The rest of the time, the Aldridges acted as if the corporations didn't exist. They wanted to be Jerry Aldridge wanted to be the declarant, not his company who owned the property. He wanted to make all the decisions, and he and his wife would be on the design review board. All those kinds of things. They acted as if they had a sole proprietorship, and they went about that in a way that was very abusive in the first place. But in the second place, they didn't say this is a corporation that is handling this matter. It is us personally. We are the show, and that came through to the jury. The jury saw it, and Judge Jansen saw it, and they couldn't help but see it because of the way it all came together.
Additional evidence to that, Your Honor, was one of the witnesses at trial, Ben Laparne, personally loaned the Aldridges $100,000. That money was not secured by a deed of trust against the golf course or against any of the golf course property. It was secured by a deed of trust against the Aldridges' personal property. Another witness at trial, Lloyd Hightower, also decided to make a personal loan to help out his friends. He wanted to help them fight the bad people in the community that were against the golf course.
That would be persuasive if the loan was made to the entity and the guarantee was made by the individual. But if the loan's made to the individual and the guarantee's made by the individual, what's the big deal?
Because these people then claimed that they were investors in the golf club itself. So the members of the community who did give the Aldridges money viewed the Aldridges as the golf club and the Aldridges personally. There was no separation of interest between who the Aldridges are and their corporate entities. Throughout the trial, their own legal counsel referred to them as Jerry and Cindy, not City Center or Information Solutions. If you heard other witnesses testify about the original declarant.
I could ask you, just when you say they thought they were investors, were they going to get something other than just a repayment of the loan? Did they have some sort of interest in profits from the venture?
No one was very clear about that. And all of these transactions occurred after depositions were taken. At the time depositions were taken of Jerry and Cindy in the summer of 2012, they had no investors. And suddenly, by the time of trial, when we discovered these deeds of trust executed, the beneficiaries being some of their trial witnesses, we learned that they now had investors in the business or with them personally. It was never very clear. It was always very nebulous. And we weren't able to get a straight answer for them at trial. The demeanor evidence really spoke volumes at trial, Your Honors. The way the witnesses would refer to Jerry and Cindy as basically the golf club. and Information Solutions. There's no separation of entity. Jerry Aldridge, during his deposition, testified that I am City Center, I am Information Solutions, they are me. I'm paraphrasing a bit. And when he was questioned about that at trial by Mr. Jeans, he had been well coached to basically recant that somewhat because the error had already slipped.
But we're here to evaluate questions of law. I mean, I've heard several times that there was a lot of demeanor in the courtroom, and that's true of every case. That explains our standard of review. But it doesn't really help us get to the nub of what we're here to review, which is whether there was sufficient evidence to submit the case to the jury. We understand people's theory about who the jury liked, but that's not terribly important to what we have to decide. What is the evidence sufficient to submit the case to the jury? I mean, assuming all the credibility questions go in favor of affirmance, what was as a matter of law, what were the pieces of evidence that justified submission of the question to the jury?
I think one of them is, Your Honor, I think I tried to get to this and I didn't do a very good job. There was no capitalization of Information Solutions. I mean, it was undercapitalized. It was simply a shell that held the golf course during the course of much of what happened here. And there was no basis to it. They loaned the money in, but individually, but they didn't actually have any capitalization of it. They also diverted some of the corporate opportunity in the sense that they treated it, and that's what was trying to say when I say they treated it as if it was them, so that the leadership, the way they conducted the matter was one of just going about it on their own. And those are the things that the jury looked at. They never disclosed, by the way, the transfer. We didn't find out about the transfer. It wasn't brought up. I'm talking about the transfer from the corporation, City Center, to them personally to Information Solution. That was actually discovered by the manager of the association, who had been doing some digging on another matter and found out that, in fact, City Center no longer operated and owned the golf course. So it's those kinds of things that brought the jury, I think, to the conclusion that, in fact, they just plain disregarded these corporations and that they were acting in their own capacity. There was no consideration. I think the biggest thing is there was just no consideration for any of those transfers. Any other questions?
Well, I'm curious, what in the documents your clients signed or the CC&Rs would lead them to believe, or was it their view that under no circumstances could the golf course ever be changed?
I think what brought that on was just the entire picture. If you look at it, and we plead this ad nauseum, but I mean, the fact of the matter is, when you drove down the main stem to get to the property, there's a big billboard that says this is a golf course community. Arnold Palmer's on the golf course. Picture, you come into the community, you see the golf course, you start to investigate the property. Mr. Thinnis happens to be in the business of doing property investigations, and he went through all of this material, and every place you turned, it said golf course. It never said.
That just tells you that it's an attractive property. I mean, there's nothing that lasts forever, or very few things that last forever in the landscape of Arizona real estate. The state looks very different than it did 40 years ago. What's the assurance that that's going to stay that way?
I think what the assurance is the promises that were made, the representations that were made that you were buying into a golf course community. Mr. Thinnis, as an example, paid $350,000 for a lot that if it was worth $100 in any other subdivision would have been a shock.
Well, what's the expectation? Assume the golf course is simply not profitable after 1 year. What's the expectation? And let's say the golf course owner just says, I'm going to walk away from it. What's the expectation that someone is going to manage a golf course and lose money? In
this case, what the homeowners, as they came in, were told is you could buy into the golf course. At the end of the day, when the project is completely finished, the golf course will be transferred over to the owners. the members of the golf community, okay? And there was a whole process for that. In fact, Mr. and Mrs. Aldridge were members of the golf course under that regimen. They knew about that when they came and bought the community.
So there was an expectation that at some point this golf course would be transferred with no further consideration to the lot owners?
I'm not sure it would have been with no consideration. That wasn't part of the
But
plan.
after this much litigation, that's the kind of thing you would know, isn't it? I mean, what was the anticipated deal? And I think we should really stick to. It's hard to ask questions and have two lawyers just responding. I mean, if this is your issue, let me just hear your answer, please.
Sure.
The answer is that there was a process in which they would be entitled to purchase the golf course or take deed to the golf course. There would have been a price for it. It would have been limited. It's a de minimis kind of
Is
transfer.
there an option?
There was an agreement that said, I don't know if you could characterize it as an option, but there was an agreement that said that at the end of the day, that's what would happen to the golf course.
Clients try to exercise their rights under that agreement and purchase the golf course.
Because Mr. and Mrs. Aldridge took over the golf course before that occurred, and nobody got a chance to do that, okay? It wasn't they took over the golf course and made it clear that they were going to do something else with the golf course.
Did your clients make demand?
We did have discussions about a purchase of the golf course, Your Honor, but they were in a settlement context. I'm not in a good position to go into
I
that.
understand, but before the Aldridges or their entities got a hold of the golf course, did the community make a demand under the governing documents to acquire title to the golf course?
No, they did not.
Okay, I mean, isn't that what their expectation was?
Their expectation was when the project was completed that they would have an opportunity to buy the golf course, yes.
But now that you're saying that their expectation was really that the golf course would just be there.
Their expectation was that the golf course or some open space would continue as long as they owned their properties, yes. And that was what they were told when they dealt with the people who brought the client, or who dealt with the clients, the salespeople who came in, were told them.
Well, let me ask this. If instead of, I mean, we have multiple levels of complaint here. It seems, on the one hand, your clients wanted a golf course. I understand that. At the most extreme level, they certainly didn't want an RV park. I understand that.
Correct.
But golf courses haven't been doing that great. And there's no reasonable expectation that somebody is going to come along and just pour money into it so that they can play golf. The question becomes, what are the legitimate uses of that land under the governing documents in your view? Could the golf course have been turned into luxury lots?
No. What you could do, because they would then not be a residential use, you could do is turn it into a park. You could turn it into open space. It's drainage now.
So you couldn't make any money from it?
No, that was clear. I mean, you were paying a premium for your lot so that golf course would remain a central feature of the community. It's a little bit like saying, you can pay me a premium for the lot so that you'll have this ambience in your community, and oh, by the way, when it becomes inconvenient, guess what? I don't have to do that anymore. I'll do something else. That's not the law. That's Wild West real estate at its worst, which is what the Aldridges are proposing here. I've been at this, as you probably can figure out, I've been at this since the 70s. And I mean, this state has worked diligently to get away from Wild West real estate, bait and switch, and that's exactly what was going on here. It's that simple. The public policy issue that we're facing here is, are we going to go back to bait and switch real estate? And I don't think that's what this court wants to do, and that's not what Shalimar says that this court should do. And I think if you look at the facts of this case and the representations that were made and the plat and all the things that occurred as this property came into existence and people purchased into it, what you find is it's Shalimar all over again. And they can say that they didn't know about it, but the jury didn't buy that. That was presented to the jury, and the jury didn't buy it. They knew about it. They were members of the golf course community for 3 years prior to buying the property, or 4 years. So what we've got here is we've got the traditional, if it isn't convenient to me, I get to change the rules of the game. That isn't what we're trying to do here, I don't think. With the Subdivision Act, with all the things that have come on in recent years, what we're trying to do here, from a public policy standpoint, is we're trying to make sure that we give people what they bargained for. And there's nothing in the record here. They talk about Section 2.5 of the CC&Rs. That subject, it's a part of a whole number of items that show you, as in Shalimar, that it was the purpose of the original developer to make the golf course the center focus of the community. There would otherwise be no reason to have relationship. It says they have the right to change the tees, they can plant trees, they can do a whole lot of things. It doesn't say they can close the golf course and turn it into RV park.
But it does say they can cease operations of the golf course.
They can stop operating the golf course. That is true. But what you'll end up with then is you'll have a nice piece of open space in the middle of the community. That's what's happened to most of the golf courses that have failed. By the way, there's also no evidence that the golf course failed.
Would it be a nice piece of open space if a golf course is suddenly shut down, not watered, not maintained, just left to its own devices?
Yeah, unfortunately, you'd have to go see the property, but it's right in the sand dunes up above the lake and right above a wildlife refuge that is, in fact, an open space, that exactly what this property would turn into if you did.
And I know we're over time, but I want to just clarify your position. Your position then is that if the golf course was not a viable business, somebody other than your clients was expected to incur the cost of holding a non-productive asset forever.
That is correct, Your Honor, and it probably would have been the association that would have ended up doing that.
Okay.
Thank you. And counsel, we'll give you an extra 2 minutes.
Your Honor.
Oh, I'm sorry.
Your Honors, let me hit a few things quickly. First, answer Judge Swan's question about what evidence in the record are concerning how the golf course could change. I cited the CC&Rs, also the lot purchase contract, which is ER 484, provides it sections 4, 8, 22, 23, and 31, the various things that we rely on, the integration clause, that there are no oral representations that were made that people can rely
All
on.
fairly standard stuff, though. Is there anything that any lot owner would have coming in that gave them any fair notice at all that you might be buying a fabulous spot next to an RV park?
Your Honor, I mean, that I was getting to in the lot purchase contract where it's noting that the property could change. Mr. Jeans brings up the Shalimar case, and I think comparing this case with Shalimar decides the case. Not the way he thinks, but in Shalimar, you had a situation where the people were expressly told that the golf course could not change for up to anywhere between 25 to 40 years, or I think 40 to 65 years. There were express statements in the CC&Rs guaranteeing views, saying that also that the golf course couldn't change. When the subsequent purchaser came in and wanted to raise the golf course and put in condominiums, he was expressly told about these promises. And that's a situation that's quite different than the situation here. Also, in
The owner is not aware that the purchasers were told that there would be a golf course there?
Your Honor, when I think, when the golf course was originally built, everyone hoped that it would succeed. I mean, of course, everybody thought that the golf course was going to succeed. The issue here is whether the legal documents provide that the golf course could change. Does the zoning say that it could change? Yes, it does.
And sorry to interrupt, but what in Shalimar, was there a difference in the documents in Shalimar?
Absolutely, Your Honor, absolutely. First of all, the developer in Shalimar expressly promised the lot owners that the golf course would remain the same for 40 to 65 years from the time the lots were sold.
In the written documents?
In the written documents. There's no evidence of any such promise here. Second, the successor developer was told of the restriction, but still wanted to raise the golf course. Here, City Center doesn't want to raise the golf course. I mean, this is their business plan to save it, frankly. In Shalimar, the implied restrictive covenants were consistent with the express promises made in the CC&Rs. Again, Shalimar, the CC&Rs had 6 express covenants regarding the golf course, especially retaining the views of the golf course. That simply doesn't exist here. And the applied restrictive covenant that was asserted at the trial court it is directly contradictory to what's in the CC&Rs and the lot purchase contract.
So if zoning allows a glue factory, the association is prohibited as a matter of law from seeking injunctive relief against that.
Well, you can seek the zoning, as the Supreme Court held in the Spur Industries case, it's a factor here. It's not a conclusive factor as a matter of law, but it's a factor of what people understood what they were buying.
But if it's a multi-factor analysis, then don't we return to what the jury held or what the jury found?
No, Your Honor.
Well, go ahead.
First of all, the bona fide purchaser doctrine eviscerates all the thinnest plaintiff's claims. That's step one. Second is that this court's holding in the Schilling case, holding that there was no express covenant, no express agreement between Mojave County and the original developer, that eviscerates a lot of their claims as well. So what we're left with is a nuisance case where the jury has held that there was absolutely no damage over 3 years done, and you have a remedy that is grossly disproportionate to what the actual nuisance is. You also have a situation on the easement claims where we won on both the trespass claim and the breach of contract claim, but the jury held against us on one of these claims for overburdening an easement that simply doesn't exist at Arizona law. I mean, overburdening an easement is either a breach of contract or it's trespass. We won both those claims. We also won the claim on the golf course easement claim. We only need one of the easements to use the roads there. So the injunction doesn't make any sense by the jury's own findings here, since we won both trespass, breach of contract, and the golf course overburdening claim. Your Honor, I see I'm out of time. Thank you very much.
Thank you all for your argument. We'll take this matter under advisement and issue a decision in due course. That we're adjourned.